The Senate Committee on Oversight will come to order. Hello, Madam Clerk.
Hello, Mr. Chairman.
Please call the roll.
Chairman McBroom.
Here.
Senator Lucido.
Here.
Senator Tice. Here. Senator McDonald. Senator Irwin.
Here.
Mr. Chairman, there are 4 members present. You have a quorum.
Thank you, Madam Clerk. Will guests and members please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, first item of business is to adopt the minutes from October 8th. So moved by Senator Tice. Hearing no objection, the minutes are adopted. Now we will take testimony on Senate Bill 201 and House Bill 4336. So Senator Nesbitt and Representative Johnson. Welcome to the Senate Committee on Oversight.
It's good to be here. It's got a good committee. Probably the best policy staffer too. So that's good. But no,
I called in all the favors I had.
It's all there. No, I remember watching in back in February, and you guys do your job, very thorough job. So, well, thank you, Mr. Chairman, for the opportunity to come before you today. As this committee aware, the Auditor General is a critical component of legislative oversight of the executive and is a key part of ensuring that we have efficient, effective, and accountable state government. To perform that role, the Auditor General must have access to the pertinent records of the program he is auditing, including those that may have some confidential requirements. Many of us believe it's already clear that the Auditor General should have access to all the department records necessary to complete their duties, but some in the executive branch need that to be made a bit more clear to them. And that's really what Senate Bill 201 is all about, and House Bill 4336 is. Clarify the powers and duties of the Auditor General already possessed via statute and by the Constitution, and more specifically, this legislation really clarifies that the Auditor General and his staff have access to confidential records and that they have the same duty to keep those records confidential. If the Auditor General staff violate those confidentiality agreements, they would be subject to the same penalties an employee of the department would be subject to. So it clarifies the state agencies who provide confidential records to the Auditor General are not subject to any penalties for providing those records. This legislation had overwhelming bipartisan support in the legislature over the last few years. I believe Representative you sponsored it before, and then Joe Graves took it, Representative Graves took it after that. And so, but it's passed with strong bipartisan support. I know Representative Johnson's legislation passed, I think 103-3 or so out of the House. So appreciate the opportunity, and so I look forward to working with you.
Yeah, not much to add. You know, Chair McBroom worked on this earlier, couldn't get it done. We're going to change that. We're going to get this one done. I had great support in the House, bipartisan, Republican, Democrat. This is just about good government. Be happy to answer any questions.
Thank you both very much. Questions? Vice Chair Lucido.
And that's right. The original sponsor was probably the best out of all of our sponsorships.
Well,
so
as Representative Johnson pointed out, I didn't manage to get it done. But I will say that the good representative's chances of getting it done without me this time are pretty nil.
Yeah,
we appreciate your support.
Didn't have such a good chair of oversight at that time.
We need to ask any questions?
Vice Chair Lucido, please go ahead.
Thank you, Mr. Chairman. I noted that it has been a retread or rerun, and it had not just bipartisan support. This bill passed unanimously in both chambers.
Yep.
The irony is, what does the governor who had vetoed this bill find offensive with the bill, if you can answer the question?
Governor Snyder viewed it as a separation of powers issue, and I would say exactly why we need this bill. This is one of the checks that the legislative branch has on the executive branch, is the ability to do an audit of their departments. In order to properly do an audit, you need to see all their information. So he viewed it as a legislative overstep. I view it the exact opposite. This is our job, our constitutional duty.
So,
and really, I believe, and I think the representative does too, is that we believe the power's already there.
Correct.
The departments don't believe the power's already there, so it's one of those things we really, really mean it this time.
So we're gonna really like codify, that word's been used so much up here, I'm codify, how about this? How about making it very clear that the authority is there and the power is vested in the Auditor General to get these documents? Otherwise, what's the purpose of an audit if you don't have the proper information? There's no value to the result. But that moving along is just a side note. Let's get to the meat of it. The concern is somehow confidential information, proprietary and/or protected information. Is there any safeguards in place that we can argue, at least from a standpoint of confidentiality? I noticed in the bill, it talked about, and this is page 5, line 24, subparagraph 10, the act does not authorize the Auditor General to access or examine records or information subject to attorney-client privilege. Now, I'm concerned that we're gonna have patient, doctor privilege, clergy, member privilege, and so forth and so on. Let's be real, everybody. If they're gonna do their job and we have to give them the power to do their job, they should also have the documents that go with it. These are just barriers and impediments from them to do what they need to do. We're paying them to do a job. Why not let them have that access? So how are we gonna fight with the privileges that are enunciated in law already?
That's part of the challenge that we're always, I think any auditor's up against, but it's something that I think the information of making clear to what's available to the auditors, that you either trust the auditors in doing their job or you don't. And this tells me that from the history of, the starting of the bill is the fact that are they hiding something or don't they want to show something? And I think this is.
I agree with you.
And
Senator knows
so,
what I agree.
so I think, has been said, in the past that, openness and sunlight's the best disinfectant, so.
I might, Mr. Vice Chair, if I might, I think some of your question will be answered by the Auditor General themselves too, but, from my experience in this, if they at least come up to the point where they recognize that they believe something's there but can't get access because of some of these other barriers, they do have the ability to come to the legislature, and we have the ability to get subpoenas if we need to see those things. But I still, your question is to the point too, that if they don't realize something's there because of documents they can't see, then nobody knows. So it's a fair question.
Okay.
But I think the auditor can better answer it probably than the sponsors.
The different departments that the governor either has the directors appointed to, this governor or future governors, it doesn't matter. Somebody has to make a decision within the department to make sure that either the information is provided or not, and if so, what standing do they have under law to withhold documents when they, in fact, have reviewed documents that are confidential, proprietary, privileged, and all those other good words that go along with it. What I'm saying to you is, our DHHS, for certain benefits, has certain things that they have as maybe as an illness or and that has been disclosed to the people at DHHS to give services that are provided. If we do an audit and that person doesn't have that documentation, why are we paying for the service? And we'll get to that, to your point. But I don't like this, and I'll tell you, I like the bill. I love the bill. In fact, I wish it said, all privileges are hereby waived in the bill. So we're not playing around and screwing around with subpoenas and 6 months and 8 months and spending all the state's money for something so simple as, look, all we're trying to do is review the documents to get you what you want and be thorough as well as complete is the word. Thank you both for bringing the bill for the third time.
Thank you, Mr. Vice Chair. Vice Chair Irwin.
Thank you, Mr. Chairman. Thank you for bringing the bills forward. Can you provide any examples of records that haven't been provided, just so I can get a sense of how this bubbled up?
Yeah, I think the OAG can probably provide a few more examples, but this goes back to some adoption cases where they tried to close off the adoption. They took it to court. The court sided with the department, and so the Office of the Auditor General didn't feel they could do a proper full audit of the processes and with adoptions.
Interesting. and we can maybe get some more of that from the OAG. My second question was, getting to Senator Lucido's point, do you know why you chose to include attorney-client privilege and not some of these other privileges? Was there a discussion that you had about the necessity of that particular element of privilege and not others? Or was this something that was maybe suggested by LSB that got in there? What was the thinking behind that particular exception?
Yeah, I don't know if you have any.
I don't know off the top of my head why that, to me, I might differ with Senator Lucido on this one. I think that there should be some safeguards there. Attorney-client privilege is pretty important in my book, so I think that's important to have in there. Be open to understand why the clergy exception or, doctor-patient relationship wasn't in there as well.
Yeah, I saw it as a vetoed bill from Representative Graves and thought this was some position that should, so that was kind of the model I used off from there.
Great, no, I appreciate the answer. I'm just trying to get a sense of sort of what we're trying to accomplish here, because what I'm sort of concerned about is, I'm always trying to think about, how could this be broken by somebody who, didn't follow the same sort of ethical standards that I think that all of you would follow. We could have an executive who might use attorney-client privilege to shield a whole bunch of documents that weren't otherwise normally attorney-client privilege. Oh. We've seen this happen a little bit right now at the federal level. We've seen it happen at other levels where, I've seen it happen at the local level where they will engage the attorney to try to privilege something. And so that's why my concern is spiked, and I'm happy to,
and that's the difference with I think the Office of the Auditor General has a good history of not releasing said documents. They do a final report on the efficacy and the efficiency of the agency or the department or the program that they're doing the audit to. But I'm always happy to look at that, what kind of powers are there to make sure that they're able to do their jobs.
Yeah, thank you, and I share your sense about the office, and I just keep getting back to Senator Lucido's point, which is that somebody within the department is reviewing these documents, right? So why are we treating the OAG differently than the people within the departments that are shielding? They're seeing them,
yeah,
right?
I mean,
and so I think that's a really strong point.
Yeah, I mean, it's yes. So, thank you.
I think that was an excellent point, Mr. Vice Chair. Thank you. You said it in the layman's way. Senator Tice.
Thank you very much. I thank you for bringing these forward. I think it's frustrating when you have to make something more legal. It's already legal, but I'd love to see us move this forward. So that's my next question. Do we have any anticipation that it'll have a different outcome than the last time the legislature wholeheartedly got behind it?
I can probably answer that if that's all right. I've been in several meetings with the administration on the issue, and we're in ongoing negotiations with them.
Thank you? Question mark?
Notice that they aren't here today, but they haven't put in a card of opposition either, so that's what I can say. But we need to move along because, this issue has been sitting out there for several years now, and so I wanted to have the hearing today and continue to advance the issue as much as we can, but those conversations continue.
Thank you.
Thank you.
Thanks, gentlemen. Representative, safe journey. All right, next, wishing to comment on the same legislation. Doug Ringler and Laura Hurst are here from the Office of the Auditor General. Good afternoon, welcome back.
Sorry, let's try that again. Thank you, Mr. Chair and committee members. If it's okay with you, I've got some prepared statements, and then we can address the questions that some of you folks had asked the legislators. I'll start. I think it's been said, but these bills do not establish new authority, and they do not represent or present a situation where there's a separation of powers issue. They seek to accomplish four main points. Clarify and affirm that the language in 13-101, which states that agencies and departments shall, upon our demand, produce for examination all books, records, and accounts. It basically reiterates that all means all. The second point is that it ensures that the request for confidential information or data is tied to an audit or examination. Third, provides protections for state employees that provide information to us so they won't be subject to prosecution for doing so. And lastly, it holds the OAG to the same standards for data protection as the agency or the department involved. Any new authority for the OAG would have to be derived through the Constitution. Examples of new authority could be like auditing local units of government or private citizens or performing executive branch functions, having the ability to place people under arrest, and many, many others. Those would have to come through the Constitution, not through statutory changes. Statutes regarding our access to records dates back to 1919. And at that time, the law said that the state government, it required all officers of the state government to produce the books and accounts of their respective departments. And then in 2003, the law was changed to say that, like I already said previously, that upon our demand, all books and records. And so here we are 100 years later, and we're still discussing what the words "the books" and the words "all books and accounts," what it means. And in short, what we're asking the law to do is affirm that "the" from 1919 and "all" from 2003 means all. These bills align the statute with our current operating practices for the last several decades regarding the access to confidential records. It also aligns our office with many other states across the country. We noticed that 46 other states have the word "all" or any type of language within their statute, and 19 of them then went even a step further and made reference to confidential in some fashion. Also, a little historical perspective. In 1993, Attorney General Kelly issued an opinion, 6749, that says we possess entirely separate constitutional and statutory authority for demanding access to records, not bound by the restrictions placed within statutes, including records that would otherwise be deemed confidential. Those are his words. He also said that the confidentiality laws in specific statutes are binding on the OAG to prohibit further disclosure. Again, we tried to codify that within the bills in front of you. In 1972, A.G. Kelly said that as a constitutional officer, we actually stand in a better position to review records than a statutorily established agency. And one more passage from him in 1971, he was so strong about our authority as he said that when the challenge arose regarding access to records, the statute that allowed a patient to consent before reviewing medical records was irrelevant and immaterial to our legal right to review those records. That's how strongly that language had been even back in 1972. Lastly, there's been a lot of conversation lately about separation of powers, and I wanted to read to you a few passages from the Constitutional Convention relative to our office and the separation of powers. On page 1675, it says, the most important aspect, this is a quote, the most important aspect of the legislative auditor general's function is his duty and power. This, coupled with the power to investigate pertinent to the conduct of audits, is the backbone of the office itself. It's set out with some detail, and necessarily so, because unless this power is spelled out in the Constitution, it will undoubtedly be challenged in many ways as a violation of the separation of powers. Second passage, page 1680. There was a question that arose about why the legislature doesn't establish a statutory auditor instead of a constitutional auditor, and the response was, and again a quote, however, there is very grave doubt as to whether that legislative auditor, meaning a non-constitutional one, would have the authority to operate within the executive branch and do what an auditor general or legislative auditor established by the Constitution can do. This, of course, is the reason for placing the provision in the Constitution, because there would certainly be doubts about the powers of a statutory auditor general. And then they also added, I think if we were to set up an auditor to go in and audit those agencies in detail, there would be considerable question about the violation of the separation of powers doctrine unless the legislative auditor had the constitutional authority we propose to give him in this Constitution. One more passage. This is a little bit shorter, 1713. The whole purpose of placing this man in this office in responsibility to the legislature is to provide that his basic powers could not be subject to pressure, influence, or veto from the executive branch, which is he is continually called upon to investigate and check pursuant to constitutional post-audit duties. So I mean, clearly the Constitutional Convention predicted this day, I guess you would say, even back in the early 1960s. Lastly, not just the Constitution, existing statutes, the AG opinion weren't persuasive enough. Also, our auditing standards are strongly worded relative to having sufficient access to all records. In fact, those standards require us to report situations where our access to data or personnel has been limited by the auditee. So again, to align with our auditing standards, if those circumstances occur, then we issue a public report and we say that we were limited. We call it a scope limitation, why our scope was limited, how it was limited, and what impact it had on us drawing conclusions. With that, I'm going to turn it over to Laura. She's got a few comments to make relative to how it impacts our day-to-day operations, and then we'll address your questions.
There you go. Good afternoon, and thank you very much for letting us come here to speak with you today. I'm just going to give a high overview of how the changes would impact our audit processes. I have submitted a more detailed testimony, and we also submitted a talking points document that has more information. Access to all records of a program under audit is necessary to independently and objectively assess the efficiency and effectiveness of that program. It's imperative to the integrity of the independent audit process and compliance with auditing standards. If access to all or a portion of a program's records is delayed or denied, it will impact our ability to complete or timely complete audits and make public recommendations related to that program. If we are delayed in or cannot provide the legislature with independent and objective assurances about these programs, we often ask the question, then who will? We think you would have to rely on state agency self-reporting in those cases. Doug and I both have over 30 years of auditing experience, and we have faced frequent challenges to our access to information over those years. These challenges have become more complex with the introduction of confidential data protections and the increased number of information systems. The state maintains over 1,500 systems. Therefore, we use electronically stored information in almost every audit, and oftentimes that information is considered confidential. Passage of these updates would help to clarify access-related agency concerns as well as facilitate the timeliness of our audit reports that we issue to the public and to the legislature. And I'd like to provide a few examples of where we've looked at confidential data or where we've had access delays. The first one, during the Grand Rapids Veterans Home audit, we checked criminal history records to ensure that persons with certain convictions were not allowed to care for veterans. We also viewed medical records to determine if specific medical instructions related to fall alarms and prescription medications were followed. The audit resulted in multiple hearings and ultimately significant changes to benefit the veteran population in Michigan. During the Child Protective Services investigation audit, we did experience a delay in accessing case file information, and it did impact the timeliness of issuing that audit. But once we accessed and tested the data, we were able to identify several significant weaknesses in the investigation process that have led to multiple hearings and ultimately significant changes that will help to address safety and security of children and our caseworkers. As was mentioned earlier, we do have a court case that's related to adoption records. And without these records, we will not be able to provide the legislature and the public with assurances that the department has actually complied with all the requirements when dealing with foster care children as they transition to adoption. And things that we would be looking at would be criminal history record checks of potential adoptive parents, central registry checks, or if they've evaluated if there's a family member that could adopt these children instead. We also have experienced a delay in accessing information from the Unemployment Insurance Agency for testing in another audit. The main issue here was the Unemployment Insurance Agency wanted us to pay for data. We can't pay for information because we can't maintain our independence if we do so. The delay exceeded a year and a half, and after sending a letter to the legislative quadrant and the governor's office, the Unemployment Insurance Agency finally agreed to share the data with us. Those are just 4 examples, so I think that concludes our prepared comments, and we'd be willing to answer some questions.
Which only goes to show how much, I think, even for us to do our job, they charge us FOIA, for things, and it's ridiculous. Mm-hmm. Isn't there also a situation that we dealt with when I was in the House, where it involved the counties getting the reimbursement for the foster care issues, child care
The child
issues.
care fund?
And the Auditor General was having trouble in that situation as well, accessing things. And you even have a court decision on your side, and the department refuses to recognize it.
Yes.
I will add, just, and then take your question, Vice Chair, that, you know, the previous administration's veto of this, and even now, the main discussion point is, are these bills an expansion of power for the Auditor General? And as the Auditor General just reported to you, that's not at all the case here. That's not the attempt. The attempt is to simply clarify what we believe the Constitution and law and Attorney General rulings already clearly state, where the access is supposed to be. We're not looking for an expansion of powers at all. But that was greatly misunderstood by the previous administration, and it's something I'm working very hard to make sure is clear in the ongoing discussions with this administration. Vice Chair Lucido.
Thank you again, Mr. Chairman, and thank you both for coming. I like to draw your attention to the Section 1. It says, as provided in subsection, or Section 53 of Article 4 of the State Constitution 63, you shall, that means you must conduct audits and examination of all branches, departments, offices, boards, commission, agencies, authorities, and institutions of the state. Now, I know that there's a protocol that auditors follow, because when you first came before this committee for oversight, you had said, these are the procedural rules that we follow. We have to. It's our practice and our standard. Then it goes on, and in regards to, this is really troublesome. In the law business, when anything is confidential and protected, we go before a court of law and we get a protective order. It's to protect those that the judge finds may be offended by what has been disclosed. So when I go down here, it's about public trust. This whole theory of why we're here is about protecting the trust of the public. If we're not doing our jobs the way we should be in this committee, or you should be as an auditor, there's sanctions and penalties. If you don't have the right information presented from the beginning, how have you been doing your job under these rules? And I need a truthful answer, because if you're prevented from getting documents that are part of your audit protocol, how in hell are you doing your job?
Well, what we do is we obviously try to negotiate that out with the department. And, you know, Laura cited some rather extended timelines that we've worked through to try to do just that. Ultimately, we have to make a decision that those documents are going to come or they're not going to come. And as I cited, the auditing standards say to us, we need to say that. We couldn't finish the job we tried to do because we couldn't get the information we needed to do that job. I mean, we obviously can't go, steal the records. We can't hack into their electronic systems to get the records. And so that's really the only recourse that we have.
So I want to be very complete, Mr. Chairman. I want the members of this committee to understand where I'm coming from on this. Line item number 10, page 5 of this, subparagraph 10, the act does not authorize the Auditor General to access or examine records or information subject to the attorney-client privilege. Yet, when you go to page 6, confidential information, quote, means information that is subject to a legal duty to not disclose its contents. We get away with this attorney-client privilege. That's got to be asserted by those that have the privilege or hold the privilege. I want you to realize that the privilege in a state record is waived by giving the information to get the benefit conferred upon them. It's waived. You've waived a privilege. This makes no sense to allow a record to continue to be subject to an attorney-client privilege when you're asking the state for something that we're relying on and giving you as a benefit. If there is a privilege and it is confidential, then you have a legal duty not to disclose it. You can get that from your attorneys and says, is this protected? I think we take it out, line 10, about attorney-client, and I'll tell you why. If somebody has a medical patient privilege relationship and they're asserting a benefit from this state, we as stewards on the fact of the taxpayer who's paying that benefit should be able to look at how and why and what for we're doing this. It makes no sense. And if they're claiming a privilege, it's waived under law by asserting a benefit by way of application. You've opened the door and waived the privilege. And I think that you've protected yourself in the bill under subsection C that says confidential information, quote, means information that is subject to a legal duty. What is the legal duty of your department not to get the information to us as legislators that's accurate, correct, and complete? There's a conflict right in and of itself in this rule that I want to make sure we discern it before releasing it at some point in time. So I hope, Mr. Chairman, that everybody sees what I see, because it's obvious that if we don't give them those records and everybody's claiming privilege, we're never going to get anywhere, and we're going to waste a lot of time.
A couple of comments relative to that. I think Senator Irwin asked a question about, why that passage was in there. We agreed to put that in there because we felt that, first of all, we felt that it might help foster approval and passage. People thought that there were reasons that people may object to it if they felt that issues that were of attorney-client privilege were subject to our review. Part of the reason that we didn't object to putting that in there, and quite honestly, there's not a lot of audit value in a lot of that stuff, because we're auditing to criteria, we're auditing to what happened, not the discussions that would go on between the departments and their legal staff. The path that they ultimately decided to take isn't something that's really subject to our audit process. What they did with those decisions certainly is. And so we felt like that wasn't a big issue for us. I mean, I'm not an attorney. I appreciate your legal analysis there. We didn't feel like it was worth holding up the legislation for something that didn't seem like a big issue to us. Certainly, if they tried to extend that to issues of doctor-client privilege or psychologist, patient privilege, those types of things, those definitely fall within our purview, because we're auditing against the payments, and we want to make sure that the services that people were rendered from the state were legitimate. So medical records, as Laura indicated in her testimony, become a very important part of our audits.
Can I also add that we felt that if it was truly attorney-client privilege, it doesn't have audit value. But if we feel somebody's trying to make it privileged so we can't see it, we felt we could subpoena the information, and then it would go before a judge and they could decide whether it truly was the privilege or not.
I would think that all information given to you may have audit value. It's just, what is it that's given to you to discern that? The last thing is, if this confidential information, whatever it may be, electronically or by paper form, has been disclosed, even through your agents that are appointed on your behalf to do a specific job, there's penalties involved here. So I guess I want to know what the state, whoever that may be, could be the executive branch that may have a difference of opinion, but for everybody to work on all cylinders in this environment that we're in, we need information that is open, honest, and more importantly, clear for you to do your job.
Yes.
But be that as it may, I just think that you may be fighting yourself with the attorney-client privilege, because I would insert that every time, and now you got to take me to court. I'm waiving the confidentiality of privilege. And you have the burden now, it's shifted, to bring me to court to ask the judge to go ahead and lift the privilege. I'd leave it alone and let them assert the privilege and explain why to a judge.
One of the things that we learned from our legal counsel was that, I'm an attorney again, but if somebody asserts attorney-client privilege and it is in fact not the case, I guess that's the...
But why waste the time?
No, I understand, sure.
I mean, turn over the information. If we're paying you benefits and you're doing an audit on the benefits that they're receiving and you learn that there's fraud going on, there's a reason that we're doing this, and it's to open up the gates to disinfect the problem that we have in the state. No further questions. Thank you.
Thank you, Mr. Vice Chair. Vice Chair Irwin.
Thank you. So my question has to do with, and maybe I'm just going out on a limb here, but the intersection between federal laws and state law. Because obviously there's nothing that this legislature can do to alter, change, or, you know, otherwise sidestep any of the federal laws. So the one that comes to mind obviously is HIPAA, right? If I'm a DHHS employee and I have certain obligations under HIPAA to maintain confidentiality of records, if I disclose those records, I'm committing felony level, you know, time in jail, tens of thousands of dollars in fines. That's all immediately implicated. So how does this get around that, or how do we deal with that in this legislation, if you can speak to it?
Yes, this is directed specifically at state law. We are aware and we deal with some of the federal rules. I think the federal IRS rules are a good example of that. The HIPAA laws that you cited are as well. But the federal government has been down this path before too, and they have provisions for audits to occur and obviously to access information in the right circumstances. You know, with the IRS laws, for example, you know, we're not allowed to use IRS information unless it's to do an audit of tax-related work. We can't use the information provided from somebody that they put in their federal tax return for other purposes. So, or if you have others that you want to add, but this is very specifically directed at state law only.
Right, and so what you're telling me is that any of those concerns I may have are actually dealt with in federal law, and that with respect to taxes and healthcare, there are exceptions that allow you to do your work and do not, I'm actually not so much worried about implicating any problems for you. I'm actually more worried about implicating problems for the department folks who are going to be handing you information. So they're not committing a felony by handing you information in this way because the federal law actually allows them.
Right, because in one case, the biggest federal audit we do, so to speak, is the single audit, and we're acting as the agent as the federal government at that point. So certainly they're giving us the right to look at that information. Otherwise, their auditors would have to come and do it too, and they'd have to do that through 50 states and et cetera, et cetera. So we act as their agent.
Problem solved, because it wasn't even a problem. Thank you.
Great.
Great question, Mr. Vice Chair. Thank you. Senator Tice.
Thank you very much. I was just picking up on something that you said with respect to the attorney-client privilege. You feel that with this language in here, it has a better opportunity for actually passing?
Yeah, that was, yes, that's the long and the short of it, yes.
Okay, that was what I wanted to confirm. Thank you.
Thank you, Senator. I don't think we have any other questions for you. Thanks very much for coming in today.
Thank you for your time.
Okay. So now we'll take up Bill 4468, and John Mikowski from Rep. Johnson's office is here to testify. Welcome to the Senate Oversight Committee, John. Hold on a second, John. I guess Tom Lambert is also willing to come up at the same time.
Perfect.
Great.
Thank you, Mr. Chair and committee members. My name is John Michkowski with Rep. Johnson's office, and the representative is sorry he had to run back to session. So, House Bill 4468 modernizes FOIA by giving the requester the option to specify the method in which communications relating to a Freedom of Information request will be delivered. Currently, FOIA allows a requester to specify how a public body should fulfill a request, such as in an electronic format via email. This allows requests to be fulfilled in a manner that is both timely and convenient to the requester, as well as avoiding wasted time and resources copying and mailing potentially hundreds of pages of documents. However, while this provision exists for fulfillment, it does not apply to responses from the public body to the requester prior to fulfillment, such as notices granting or denying requests and requests for fees. The result is that some public bodies sometimes choose to respond via first-class mail, even when the request is received via electronic means. This not only unnecessarily slows the process down, thus negating FOIA's intent to facilitate timely access to public information, but it's also an unnecessary waste of public resources. House Bill 4468 simply adds an intuitive and common sense requirement that the requester can specify the method by which the communications relating to the FOIA request will be delivered. The bill passed unanimously through the House Oversight and Ways and Means Committee and overwhelmingly through the House. And now I'd like to turn it over to one of Rep. Johnson's constituents, Tom Lambert, to give the background of the problems that House Bill 4468 is seeking to address.
Good morning, or afternoon now, committee members. My name is Tom Lambert. You may know me as President and Legislative Director of Michigan Open Carry. We've been using FOIA a lot over the past couple of years, and we've learned a number of the games that are played. This is one of those games. It seems the theme behind today's hearing is, why are we here? Do we really have to do this kind of stuff? Isn't this already in the law? Shouldn't the government already be doing these kind of things? Yeah, that's exactly what we're doing right here. We've used FOIA a number of times. We found that with large bodies, the Michigan State Police and the city of Detroit are the two biggest offenders here. You would think that, hey, you don't have to mail me something. You don't have to send anything first-class mail. Just send me an email as a response to my FOIA request. I emailed my FOIA request to you. Just reply to me in the same way I communicated with you. But they don't do that. It's a fight to get them to try it, and it's a fight that they're winning because we effectively have nothing in the law to hold their feet to the fire here. So what they end up doing is they wait as long as they possibly can, out to the very last moment, to send a response to our request. And what they do is they set it in first-class mail, which slows the process down. That mail takes time to get to us, takes time to get into our box, for us to get it, read it, and then respond to them. Every day that they slow the process down is a devaluation in the information that we seek. And if it's in today's time where computers are such an integral part of our society, why would you send something first-class mail when the other side specifically asked you, please email me? In fact, I'm not even going to give you an address to mail me at. I'm telling you, please send me email only. And so what they do is they go online and they look up an address because we didn't give them one. That's the extent to the games that they play to find ways to slow the process down, to give us trouble, to anything that they can do, any roadblock that they can put in between us and getting information. There's a lot that I would love this oversight committee and auditors, if they're still here, to look into with the Michigan State Police and the where the money goes for concealed pistol licenses, but that's another story. For now, we're trying to use FOIA to look into it ourselves, and these are some of the problems that we run into. So simply what this does is says, look, if we ask you to respond to us by email, please do. One of the other problems that this allows us to get around is oftentimes, public bodies will forget to respond or not respond in time, just kind of hoping we go away. I'm sure that happens all the time. They just ignore a response and the person never comes back. Well, we pay a little bit more attention. And so what we've had plenty of times is we'll email them and say, hey, we haven't heard from you. Oh, a response is in the mail. And then we'll get that response and we see that it was post-dated a couple days after their deadline. Same day that we emailed them to check in on what was going on, ironically. But when we open the letter, when you look at the date on the letter that says, hey, you've been denied, or here's the fees, or all that kind of stuff, oh, wow, hey, guess what? That date that's on the letter just happened to be the last day of the deadline. There's been a few times where we've been able to go back and say, no, I don't want the paper letter. Please give me the Microsoft Word version or the PDF version, the electronic version that you first came up with, because we've had to file another FOIA request later to get the electronic versions of the documents that they used to respond to our first FOIA request. And on every electronic document is something called metadata. If you click the properties, you can find out when that file was created, who saved it, when they first created it, when they first saved it. And so you can see for attorneys on the committee that understand the Michigan Rules of Professional Conduct, when the date that the attorney, especially for the city of Detroit that actually responds to FOIA requests, put in this document is 3 or 4 days before the date of the electronic document that they created, raises some pretty big suspicions that someone might be not telling the truth. It's really easy for them to hide if they can just use first-class mail whenever they want. And that's one of the reasons that they use first-class mail instead of electronic transmission. I could go into a lot more, but I really don't want to take much more of your time. I'm very happy to answer questions if there are any.
So, just so I'm totally clear,
Sure.
right now, when you request a FOIA, you can specifically tell them what medium you want that information transmitted to you in.
Yep, so if I request 500 pages of something, I can say, please give me the 500 pages electronically, and they have to do that. But all of the back and forth communications of, here's how much it's gonna cost you,
You can't
here's what.
specify that.
No.
So, is there, I mean, if somebody just leaves it blank as far as what medium they want the information in, you're okay with the default then for the department remaining the mail, or?
That's a great question, Senator. This bill started off as defaulting to the same medium. And I think that's the way we should do it is, if I request in whatever medium, I've already signified that's the medium I want to communicate in. The public body should respond in the exact same medium. However, there were a number of concerns brought up of, well, what if they send a FOIA request in via carrier pigeon? That was literally a concern that was brought up.
I would say more reasonable is probably, what if they send it by fax?
Sure.
And you need 1,000 pages by fax? I mean, we're gonna have to charge you more, because, I mean, that's gonna be a lot more expensive than sending it other ways.
And your response is exactly the response I have. You dictate a certain medium, then you repay for that. So to get around those objections and to just simplify things, we kind of went, well, what if we just allow the requester to specify the medium? That won't help everyone, and I think a lot of public bodies will still play games here. But those that understand the process and know what they want to get, it at least gives us the tools to do that. So it doesn't go as far as I would like, but I think it's a great step forward without a lot of problems.
Other members have questions? Vice Chair Irwin.
I'm curious about how the exception for folks who do not have the technological capacity to use electronic mail got in there. Was there a specific group that requested that? Did anyone come forward and say that, we don't have the technological capacity to send email?
I believe when we were talking with the locals, such as Townships Association and such, just clarifying that in case there was any communities such in the UP or something that had a situation like that, that there was just an out for that.
I can say we don't have any that are using carrier pigeon. So.
Yeah, that's what I would
There we
think.
go.
And I'm just sort of wondering, is it, I mean, this is getting picky and it's not really central to the bill, but, how does this community assert that they do not have the technological capacity, and what does that really mean? And, obviously, some communities are choosing not to have the technological capacity because it would be too expensive for their purposes, and so they've made a choice. Does that really mean that they lack the technological capacity? I mean, I don't want to.
It's a great question. And let me tell you how I interpret this, and for the members of the committee, if you interpret it differently, then let's discuss it. I interpret this as future-proofing this new addition, mainly to target fax. As fax continues to go by the wayside, I think it's fair to say to any public body that if you don't have the capacity to send a fax, then I don't want you to go out and buy a fax machine to respond to one person. As far as electronic mail and email, a Google account's free. If you have access to the internet, the Google account's free, send the FOIA response that way. I would have a very hard time believing any argument from a public body that as long as they have internet access, doesn't have the capacity to correspond via electronic mail, or email specifically.
Yeah, no, I appreciate the answer. I don't want to take up too much more time with this particular concern, but if and when this comes up, I might move to strike fax. I don't know why anyone's still using facsimile.
The reason fax specifically is listed as an option is I've worked with a number of attorneys as well as the Michigan Press Association, and there are people out there sometimes that do send in their FOIA requests via fax. If you wanted to strike that, personally, I wouldn't object to it.
Such a cool word. Any other questions? All right, thank you very much, gentlemen.
Thank you all for your time.
Thank you.
Okay, at this time, we need a motion to excuse absent members. So moved by Vice Chair Lucido. Hearing no objections, Senator McDonald is excused. No further business before the committee. Senator Tice moves to adjourn. Hearing no objection. We're adjourned.